Hey everyone, Elizabeth here. The Last Laugh delivers stories that leave you speechless. If you're here for it, hit subscribe and let's go.
My grandmother smelled like lavender and old books. Every Sunday of my childhood, she would pull me into her kitchen before the rest of the family arrived, pour 2 cups of tea that were mostly milk and say the same thing. Nora, the people who understand you will always be outnumbered. That doesn't make them wrong. I didn't understand what she meant when I was 7. I understood it completely by the time I was 34, sitting at a defense table in courtroom 4B of the Haverford County Civil Division, watching my mother cry on cue for a judge who had been her college roommate. Grandma Eleanor died on a Tuesday in October, 18 months before that courtroom moment. She was 81 years old, sharp as a letter opener until her final weeks, and she died knowing exactly what she was doing when she changed her will. The problem was that no one in my family believed that. Or rather, they didn't want to. What followed her death was not grief. It was a calculation. I should tell you who I was before any of this because who I was matters to what I survived. My name is Nora Callahan. I grew up in a 5-bedroom house in suburban Connecticut that looked from the outside like prosperity. My father was a civil engineer who traveled frequently and kept his emotions in a locked drawer he never opened at home. My mother, Patricia, was the kind of woman who organized charity galas and spoke about her children the way people speak about investments, always in terms of return. My older brother, Derek, was her return. He'd gone to law school, married well, bought a house 4 streets from hers, and called every Sunday without being reminded. He was golden in the way that first children of certain mothers always are, not necessarily because of his qualities, but because of her need for him to be. I was the other one. Not spectacularly failed. Not dramatic. Just insufficient. I had taken a scholarship to study archival science, which my mother announced to her friends as something with libraries. I worked for 12 years as a senior archivist and records specialist for a mid-sized estate law firm in Philadelphia. A job that turned out to be quietly, almost embarrassingly relevant to everything that came after. I was methodical, private, and I did not perform my accomplishments the way Patricia needed me to. I did not call every Sunday. I did not buy a house 4 streets away. I bought a condo in Fishtown, 3 years before Grandma Eleanor died, with my own savings and a mortgage I'd qualified for a loan. I had a partner, James, who taught high school history and made very good pasta and had no patience for family politics. I had 2 close friends. Diane, a nurse I'd known since college, and Marcus, a forensic accountant who'd become something between a colleague and a brother over years of working adjacent cases. I ran on Thursday mornings. I read more than I socialized. I was, by most definitions, fine. By Patricia's definition, I was a disappointment who hadn't yet realized it. The specific texture of her disappointment had shifted over the years, but its center remained consistent. I had not married rich, had not produced grandchildren, had not pursued something she could explain quickly at dinner parties, and, most critically, I had spent more time with Eleanor than anyone else in the family. That last part was the one that mattered. Eleanor and I had been close since I was small, in the way that certain grandchildren and grandparents are close, like 2 people who simply recognize each other across a generation. She had been a legal secretary for 30 years before retiring. She loved crossword puzzles and documentary films, and in her later years, had developed a sharp interest in estate planning that her own children found morbid and I found completely reasonable. When she was diagnosed with congestive heart failure at 79, she did not panic. She called her attorney, a man named Gerald Fitch who had handled her affairs for over 2 decades, and she began to put things in order. She told me about it during one of my weekly visits. I drove up from Philadelphia most Sundays after James started his grading routine, and she was utterly calm. "I've been thinking about what I want to leave and to whom," she said, stirring her tea. "And I've been thinking about who actually showed up." I told her I hadn't shown up for any inheritance. She laughed. "I know that, sweetheart. That's rather the point." I didn't ask her what she'd decided. It wasn't my place. I helped her organize her documents. She knew I was good at that, and I drove back to Philadelphia and said nothing to anyone. What I didn't know at the time was that Gerald Fitch had also recommended she document her intentions on video as a precaution. He'd seen enough contested estates in his career to know that clear intentions, clearly stated, were worth more than any paper document when families turned adversarial. Eleanor had agreed immediately. She'd always appreciated a well-organized defense. She recorded the video testimony 30 days before she died. I wasn't present. I didn't know it existed until 6 months after she was gone. The will was read 3 weeks after Eleanor's funeral. Patricia had organized the gathering herself at the family home, with Derek and his wife Sandra present, along with 2 of my aunts and their husbands. I sat in the corner of the living room where Eleanor had kept her reading chair, and I looked at the chair and I tried not to feel the specific grief of watching someone fill a room that belongs to someone who's gone. Gerald Fitch read the will with the careful neutrality of a man who had read many wills before and knew what was coming. Eleanor had left the family home and its contents to be divided equally among her 3 children. My mother, my Aunt Ruth and my Uncle Peter, who lived in Oregon and had called me the week after the funeral to say he was sorry he couldn't get back sooner. She had left her investment portfolio, $3.7 million in diversified accounts. To me, the room changed temperature. Patricia's face did not move for a full 3 seconds. Then it moved too much. Derek set down his coffee cup with a deliberate click. Sandra looked at her phone. My Aunt Ruth said very quietly, "Oh, Eleanor." I said nothing. There was nothing appropriate to say. Gerald Fitch continued reading the remaining smaller bequests. Jewelry to various grandchildren, a specific sum to Eleanor's church, her car to Ruth's youngest son. The portfolio designation was not revisited. It was what it was. Patricia stood up before he finished and walked out of the room. Derek followed. I stayed until Gerald was done, thanked him quietly and drove back to Philadelphia in silence. James had dinner ready when I got home. I sat at the kitchen table and told him what happened, and he listened without interrupting, which was one of the things I loved most about him. "What are you going to do?" he asked. "Nothing," I said. "It was her money. She decided. You know they won't accept that." I knew. The calls started within a week. Patricia, at first formally, she wanted to discuss the estate. She wanted to understand Eleanor's reasoning. She wanted to know if I had encouraged this in any way. I told her I hadn't. She didn't believe me. Or she decided not to, which is a different thing. Derek called next, more directly. He used the words undue influence twice in the first conversation, which told me he had already spoken to an attorney. I worked at an estate law firm. I knew what that phrase was designed to do. I called Marcus the following week. We met at a coffee shop near his office and I laid out the situation as clearly as I could. Marcus was a forensic accountant. He'd spent 15 years untangling financial disputes, fraud cases, contested estates. And he listened the way he always did, which was with total stillness and the occasional small nod. "You need to document everything," he said. "Every call, every text, every email. Starting now." "I already am." He looked at me. "You were expecting this." I was hoping I was wrong. He reached across the table and tapped my folder. "You're going to be okay. But you need an attorney." I'd already called one. A woman named Claire Sorensen, who had been a partner at my firm before opening her own practice in estate litigation. She was precise and methodical and had a reputation for being extremely unpleasant to opposing counsel, which felt correct for the moment. Claire reviewed my documents and said what I already suspected. If my mother filed a claim of undue influence, the burden of proof was technically on her, but the presence of a friendly judge could shift the practical reality significantly. "Do you know who they'd file in front of?" she asked. I didn't yet. The lawsuit was filed 4 months after Eleanor died. Patricia and Derek, listed as co-plaintiffs, claimed that I had manipulated Eleanor during her final years through sustained emotional isolation of the decedent from her family, and undue pressure exerted during a period of diminished cognitive capacity. They sought the full $3.7 million portfolio plus legal fees. The case was assigned to the Honorable Margaret Ellison. Claire called me the same afternoon the assignment came through. Her voice was carefully neutral, which told me the news wasn't good. "Judge Ellison and your mother were roommates at Bryn Mawr. Class of 1982. I sat with that for a moment. "Can we request a recusal?" "We can try. But without documented bias, it's a long shot. They went to the same school 40 years ago. She'll argue that's ancient history and insufficient grounds." "What do? We prepare as if the deck is stacked," Claire said. "Because it might be. And we make sure our case is so airtight that stacking the deck doesn't help them." I went home that night and sat in Eleanor's reading chair, which James had helped me move to our living room after the estate was partially distributed. I put my hand on the armrest where her hand had rested for 30 years and I thought about what she had said to me once about people who understand you being outnumbered. Then I called Gerald Fitch. Gerald Fitch was 71 years old and had a voice like a library, quiet, authoritative, with the kind of depth that comes from decades of careful listening. He had handled Eleanor's legal affairs since 1997. He had also, as I was about to learn, been considerably more prepared than any of us knew. "Nora," he said when I explained why I was calling. "I was wondering when this would happen." Eleanor was wondering too. He told me about the video testimony. It had been recorded in his office on September 14th, 31 days before Eleanor died, with a notary present and 2 staff members as witnesses. Eleanor had sat in the chair across from his desk, dressed in her blue cardigan, and she had spoken for 47 minutes. She described her relationship with each of her children and grandchildren. She explained her reasoning for every bequest in the will. She discussed specifically and at length her relationship with me, the weekly visits, the help with documents, the Sunday teas, and she was unambiguous. I had never at any point asked her for anything, suggested she change her will, or applied any pressure of any kind. She had also, Gerald told me, specifically anticipated a challenge. She said, and I'm quoting directly, "I expect Patricia will contest this. She has always confused presence with manipulation. Nora showed up because she loved me. That's the distinction my daughter has never been able to make." I was quiet for a long time. "Why didn't you tell us about this video at the will reading?" I asked finally. "Because Eleanor specifically asked me not to," he said. She said, "Gerald, if they accept the will quietly, there's no need to put that on the record. But if they fight it, let them fight. And then show them." She had known. She had planned for exactly this. And she had trusted me enough not to warn me because she knew I would handle it. I scheduled a meeting with Claire the next morning and I brought Gerald with me. The pretrial period was 8 months of controlled tension. Patricia and Derek's legal team, a firm called Whitmore and Associates, expensive, aggressive, and accustomed to winning on intimidation, filed motion after motion. They submitted affidavits from relatives attesting to Eleanor's visible confusion in her final year. They produced a letter from Eleanor's former neighbor claiming she had seemed easily led in conversations. They painted a picture of a vulnerable old woman surrounded by a calculating granddaughter who had strategically isolated her. Claire let them build it. She submitted clean, minimal responses. She did not tip our hand. Marcus, working with Claire, quietly subpoenaed Eleanor's medical records for the 18 months prior to her death. Her neurologist, a Dr. Amara Osei at Penn Medicine, had seen Eleanor quarterly. The records were unambiguous. Eleanor had scored consistently in the high normal range on every cognitive assessment administered. There was no documented confusion. There was no diminished capacity. She had been medically exactly what she appeared to be. A sharp woman who was dying and knew it and had made her decisions clearly. Dr. Osei agreed to testify. Marcus also cross-referenced the timeline of Eleanor's alleged isolation against my own records. Phone logs, visitor sign-ins at Eleanor's assisted living facility during her final 3 months, and my own work calendar. What emerged was not isolation. What emerged was the opposite. I had visited regularly, consistently, but no more frequently in her final year than in any prior year. Meanwhile, Patricia had visited Eleanor 11 times in the 14 months before her death. Derek had visited 4 times. My Uncle Peter had called monthly from Oregon. The picture Patricia was painting, of a daughter systematically cutting Eleanor off from her family, was not just incorrect. It was provably, documentably inverted. Claire reviewed everything and said 3 words. "We're ready." Good. The morning of the trial I dressed deliberately. Charcoal blazer. White silk blouse. My hair back. Pearl earrings that had been Eleanor's. She'd given them to me 2 Christmases before she died in person in front of my Aunt Ruth, who I had gently reminded Claire to note as a potential corroborating witness. I wasn't performing grief. I was honoring the woman who had trusted me enough to leave me everything she'd built, and I wanted to carry that with some dignity. James drove me to the courthouse. He parked and walked me to the steps and held my face in both his hands for a moment and said, "She picked right." I nodded. I didn't trust my voice. Inside the gallery was full. Patricia had brought what looked like the entire extended family. Aunts, cousins, Derek's in-laws, People I hadn't seen in years who had apparently decided this was an event worth attending. They filled the left side of the gallery behind the plaintiff's table in a show of solidarity that was clearly choreographed. Patricia wore a dark dress and an expression of grieved righteousness that I recognized from every family dinner where I'd done something she disapproved of. Derek sat at the plaintiff's table beside their lead attorney, a man named Whitmore himself, silver-haired, deliberate, the kind of lawyer who was accustomed to the room feeling like his. He reviewed his notes with the relaxed confidence of a man who didn't expect to be surprised. I sat beside Claire at the defense table. Gerald Fitch was in the front row of our side of the gallery, beside Marcus and Dr. Osei and Diane, who had taken the day off work and driven 2 hours and said nothing except, "I'm here," when I called her. Judge Margaret Ellison entered. She was in her mid-60s, professional, composed. She greeted the room in the standard fashion. Nothing in her expression telegraphed anything. But when her eyes moved to the plaintiff's table, there was, just barely, a half-second of softening that she controlled quickly. Claire had seen it too. I caught her slight nod. Whitmore's opening statement was an exercise in narrative construction. He spoke for 22 minutes, painting Eleanor as a woman in decline and me as a patient, strategic opportunist who had identified her vulnerability and exploited it over years. He used the word manipulation 11 times. He was good at his job. The gallery behind Patricia was utterly still in the way that people are still when they believe completely in what they're hearing. I watched the judge. She was taking notes. Her pen moved during Whitmore's most emotional passages. Claire's opening was 9 minutes. She stated the facts in sequence. Eleanor's medical record showing full cognitive capacity. The documented visit history. The timeline. She said, "The plaintiff will argue that presence equals influence. The evidence will show that the only thing Ms. Callahan's presence represented was loyalty, something the record shows was not evenly distributed in this family." Whitmore objected to the framing. The judge sustained it partially. Claire sat down. She was not rattled. She had expected that. The plaintiff called their witnesses first. The neighbor. An aunt on Patricia's side. A woman who had been Eleanor's bridge partner 3 years before her death and hadn't seen her after that. Each of them described in varying levels of detail an Eleanor who had seemed not quite herself in her final years, who had spoken frequently of Nora, who had seemed to depend on her. Claire's cross-examinations were clean and specific. To each witness she asked the same question in different forms. When specifically did you observe this diminished capacity? Was that observation made by a medical professional? Were you present for her neurological assessments? The answers were no, no, and no. The witnesses were not lying. They were describing the natural cognitive shifts of an 81-year-old woman through the imprecise lens of social interaction, and Claire made sure the record reflected exactly that imprecision. Then Whitmore called Patricia herself. My mother took the stand like a woman who had practiced it, which she had. She described Eleanor as a mother who had always been warm but increasingly confused. She described me as a daughter who had slowly edged the family out. Sunday visits that coincided with family calls, holidays I'd monopolized, conversations about the estate that she had overheard fragments of that concerned her. She cried twice. Both times were timed. When Claire stood for cross-examination, the room shifted slightly. "Ms. Callahan," she said, "my mother's name, my name, the surname we shared. How many times did you visit Eleanor in the 14 months before her death?" Whitmore objected. Relevance. The judge overruled. Patricia answered, "I visited as often as I could. I had responsibilities." The visitor log from Chestnut Hill Senior Living shows 11 visits in 14 months, Claire said. "Does that sound accurate?" Pause. I believe so, roughly." "And your son Derek, plaintiff number 2, the same log shows 4 visits in the same period?" "He has a very demanding career." "And Nora, the defendant, visited 53 times in the same period. Every week, approximately, with occasional additional visits. Is that consistent with your characterization of her as someone who was edging the family out?" Patricia's lawyer objected. The judge sustained it. The question was argumentative. But the number was in the record. 53 visits. It sat in the air of the courtroom like something immovable. Dr. Amara Osei testified after lunch. She was 44, precise and completely comfortable in a witness box. She described Eleanor's cognitive assessments with clinical specificity, dates, scores, methodology, and concluded without equivocation that Eleanor had shown no signs of diminished capacity in any examination conducted in the 18 months prior to her death. In your professional opinion, Claire asked, was Eleanor Callahan capable of making clear, informed decisions about her estate in September of last year? Absolutely, Dr. Osei said. Completely and without question. Whitmore's cross-examination attempted to introduce the concept of lucid intervals, the idea that someone could test well but still experience periods of confusion. Dr. Osei was politely immovable. She explained the assessment methodology, the observation periods, the distinction between social confusion and cognitive decline, with the patience of someone who had explained it to many skeptical attorneys before and expected to explain it to many more. When she stepped down, Whitmore's second chair leaned in and whispered something to him. He shook his head slightly. He didn't know what was coming. Claire stood. Your Honor, the defense would like to submit Exhibit A. She had told me we would do this in the afternoon session, after the plaintiff's witnesses had built their full case. After the jury, there was no jury, it was a bench trial. But the gallery served the same emotional function, had absorbed Whitmore's narrative completely. After they felt certain, she handed the exhibit list to the clerk. The clerk handed a copy to Whitmore. He read the description. His expression did not change, but his posture did slightly. Exhibit A, Claire said, is a video testimony recorded by Eleanor Marie Callahan on September 14th of last year, in the office of her attorney Gerald Fitch, before a notary and 2 witnesses, 31 days before her death. The recording is 47 minutes in length. We have prepared a 12-minute edited summary of the directly relevant sections, with the full recording available to the court. Judge Ellison set down her pen. The gallery murmured. Patricia turned to Whitmore. He was already on his feet. Objection, Your Honor. This exhibit was not disclosed in the discovery phase. It was disclosed in our supplemental filing on March 3rd, Claire said, sliding a document to the clerk without looking at Whitmore. Page 7, Exhibit A, described as video testimony of decedent. Counsel had 30 days to request further detail and did not. The judge reviewed the document. She looked at Whitmore. Counselor. Whitmore's jaw tightened slightly. We believed the reference was to a standard deposition. A video testimony of a decedent is self-describing, the judge said. Her tone had changed. Not dramatically, just shifted the way a room shifts when a window opens. I'll allow it. I looked at my mother. He was very still. Gerald Fitch in the front row folded his hands. The clerk set up the screen. The room went quiet in the way rooms go quiet before something that cannot be taken back. Eleanor appeared. She was in Gerald's office chair in her blue cardigan, with the particular posture of a woman who has spent decades sitting in professional settings and knows how to hold herself in them. She looked directly at the camera. She looked, to put it precisely, like herself, clear-eyed, composed, slightly amused by the formality of the occasion. My name is Eleanor Marie Callahan, she said. I am recording this statement in sound mind and full awareness of my condition, at the recommendation of my attorney, Gerald Fitch, to ensure that my intentions are clear should any questions arise after my death. She paused. She almost smiled. I expect there will be questions. The edited sections covered her estate decisions methodically. She explained the bequest of the property to her 3 children. She explained the portfolio. He explained Nora. Nora visited me every week for the last 4 years of my life, Eleanor said. She did not ask me to change my will. She did not discuss money with me, except to help me organize documents when I asked for her professional expertise. She brought me tea. She listened to me. She sat with me through the nights when I was frightened, and she never once made me feel like a burden. Eleanor looked at the camera with the particular steadiness of someone saying something they have thought about for a very long time. My daughter Patricia believes that because she is my child, she is entitled to my legacy. What she has never understood is that legacy is not about biology. It is about who showed up. Nora showed up. She addressed the anticipated challenge directly, almost briskly. If Patricia contests this will, I want the court to know. I am of completely sound mind. I have documented evidence of this with my physician, Dr. Amara Osei, who has seen me quarterly. I made this decision freely, thoughtfully, and with full awareness of what it means. I'm not confused. I am not manipulated. I am a woman who knows exactly who loved her. The screen went still. The courtroom was absolutely silent. I did not look at my mother. I looked at Eleanor's face, frozen on the screen, and I thought about the Sunday teas and the lavender smell and the 2 cups with too much milk, and I felt the grief that I had been holding at arm's length for 18 months move through me all at once, clean and complete. Then I heard Patricia make a sound, a small, sharp intake of breath, and I looked at her. She was pale. Her hands were flat on the table in front of her. Whitmore was writing something on a legal pad with the focused urgency of a man trying to look in control of a situation he had lost. Judge Ellison set her pen down completely. She removed her glasses. She looked at Patricia Callahan, her college roommate, her old friend, with an expression I could not fully read but that contained something that looked to me like the particular discomfort of a person who has just understood that they were about to do something wrong. "Counselor Whitmore," the judge said, "does the plaintiff wish to call any further witnesses?" Whitmore stood. "Your Honor, we'd request a brief recess too." "We'll take 15 minutes, the judge said. In the hallway, Claire touched my arm. "You okay?" "Yes," I said. And I was, in the specific way you can be okay while also being absolutely broken open. "Gerald's testimony is next," she said. "And then we're done. They have nothing left." Gerald testified for 22 minutes. He described the video recording session in clinical detail. The date, the participants, Eleanor's demeanor, her clarity. He confirmed that she had initiated the recording herself. He confirmed that I had not been present. He confirmed that in his 38 years of practice, Eleanor Callahan was one of the most cognitively clear clients he had worked with in a final estate review. Whitmore's cross-examination lasted 4 minutes and accomplished nothing. Then Claire stood one final time. "Your Honor, the defense rests. We'd also like to address the matter of sanctions under Rule 1023, given the demonstrably frivolous nature of the undue influence claim in light of the medical record, the visitor documentation, and the decedent's own direct testimony." Judge Ellison looked at the ceiling for a moment that stretched slightly longer than it needed to. Then she looked at Whitmore. Then she looked at Patricia. "I'm going to take this under advisement overnight," she said. "But I will tell you, Counselor Whitmore, that the court has significant concerns about the evidentiary basis of this claim. Significant concerns." She paused. "We'll resume at 9 tomorrow morning." She rose. The clerk called the room to its feet. The ruling came the following morning in 45 minutes. Judge Ellison found for the defense on all counts. Eleanor's will stood. The portfolio remained mine. In her written ruling, which I read later that afternoon sitting in Claire's office with a cup of coffee going cold in my hand, she wrote, "The decedent's own testimony, combined with contemporaneous medical documentation, renders the plaintiff's claim of undue influence not merely unproven but contradicted by the preponderance of evidence. The court finds no basis for the allegation of manipulation. The court finds, rather, a family member who showed consistent, documented, uncoerced devotion to an elderly relative, and an elderly relative who recognized and honored that devotion. The sanctions request was granted in part. Whitmore's firm was ordered to pay a portion of my legal fees, not the full amount Claire had sought, but enough to be a statement. Enough to be on the record. Outside the courthouse, in the gray November light, the extended family dispersed without looking at me. Patricia walked to Derek's car without speaking. Derek looked at me once, a long, unreadable look, and then looked away. I stood on the courthouse steps with James and Claire and Marcus and Diane and Gerald Fitch, and Gerald shook my hand and said, "Eleanor would have enjoyed that very much." "She planned it," I said. "She did," he agreed. "She really did." That evening, James made pasta, the complicated kind, the kind that takes 90 minutes, and we ate at the kitchen table with the radio on and didn't talk about the trial at all. We talked about a hiking trip we'd been planning for 2 years and hadn't taken yet. We talked about the novel James was halfway through and couldn't stop thinking about. We talked about Diane's new apartment and whether Marcus's insistence on wearing the same lucky tie to every professional meeting was a personality trait or a coping mechanism. At some point I looked at Eleanor's chair in the corner of the living room, and I thought about what I had won and what it had cost. The money was real. I knew what I would do with it. A portion to charity, a portion to a scholarship fund in Eleanor's name at the library she had loved, The rest invested carefully and left largely untouched, because Eleanor had built it over 40 years and I had no interest in treating it like a windfall. It was a trust, not a prize. What I had lost was simpler and larger. Whatever remained of the possibility that my family was something it had never actually been. The trial had not estranged me from Patricia. We had been estranged for years without calling it that. But it had made the estrangement official. There was no more pretense of repair on the table. We had faced each other in a courtroom over a woman we had both loved differently, and we had said things into the public record that could not be unsaid. I didn't know if that was loss or clarity. Maybe both. Diane called later that night. She asked if I was okay. She left me a video, I said. She planned the whole thing. She sat in Gerald's office in her blue cardigan and she said exactly what she needed to say so I'd be okay. Diane was quiet for a moment. That's love, she said. Yeah, I said. That's love. I sat for a long time after we hung up, in the quiet apartment with James reading in the next room and Eleanor's chair in the corner, and I thought about what it meant to be understood by someone. What it meant to have a person in your life who knew you well enough to plan for your defense from beyond their own death. What it meant to be that known. The people who understand you will always be outnumbered. That doesn't make them wrong. He was right about everything. He always was. If this story moved you, share it with someone who knows what it means to show up for the people who matter even when no one's watching. And if you've ever been the one in the room who was dismissed, stay. Your moment is coming.